And Alex Warren Green on behalf of Mr. Thurman. Your name, Mr. Thurman?
Notice how the judge wastes no time, straight to the point. Name, representation, and charges. These early moments might feel routine, but they set the stage for everything. Think of it like the opening chess move. You want to see who's playing white and who's on defense.
Your Honor, we are asking to set this matter for preliminary examination.
Discovery is complete.
I believe so, Your Honor.
People have their witnesses available to second.
We'll do our best, Your Honor.
Preliminary examination in person will be set September 2nd, 2025, 9 a.m. That is before Judge Perry. Bond will continue.
Thank you, Your Honor.
Thank you. And court calls the case of the People versus Christopher Taylor.
Joseph, the government people. Hello, on behalf of Mr. Taylor, who's approaching and stands to my right. Mr. Taylor, please introduce yourself to the court.
Christopher Taylor. Thank you.
Thank you, Your Honor. Your Honor, I was fairly recently appointed on this case. We are still working on discovery on this matter, so we're asking for a brief adjournment.
Did you catch that? A defense attorney asking for time and the court allowing it. In legal terms, that's called an adjournment, basically a legal timeout. Sometimes it's strategy, sometimes it's survival. What do you think? Smart move, or just buying time?
Without objection, September 4th, 2025, 9 a.m. Bond continue.
Thank you, Judge. You take this.
Court calls the case People versus Cody Wines.
Joseph, the government people.
Assistant Public Defender Sandra White on behalf of Cody Wines. Mr. Wines, can you state your name for the record?
Cody Michael Wines.
Your Honor, I'm asking for an adjournment of this matter. I believe this is the first hearing for further negotiations and to review video with Mr. Wines.
Probable cause conference, August 28, 2025, 9 a.m.
Thank you.
Bond continue. Thank you. Court calls case People versus Ma Sharif.
Joseph, the government people, Your Honor. Morning, Your Honor. Mustafa Houili on behalf of Mr. Sharif, who's to my left. Sir, please state your name for the record.
Ma Sharif. All right.
Your Honor, today's a day for PCC. There are two cases in this matter. There is a felony larceny and a unlawful driving away of a motor vehicle. Your Honor, he was arraigned last week. At this point in time, we've only received paper discovery on the larceny. We haven't received any discovery at all on the unlawful driving away. So I'll leave it to the discretion of the court judge if you'd like to do an adjourned PCC for us to get up to date with discovery, or if you want to set it out for.
Here's the tension: discovery isn't done. Discovery is like the evidence playbook, and if it's missing pages, nobody's ready for trial. The defense is pushing for more time, and the judge is pressing for answers. This is the constant tug of war in court. Speed versus fairness.
Exam a few weeks out to give us enough time to review discovery and determine what we want to do with the exam.
I don't set exam until discovery is complete. You're telling me discovery is not complete. How much time do you need to get it done?
Judge, we just need the discovery on both matters. They're still outstanding, maybe a couple weeks.
That objection, probable cause conferences will be adjourned September 4th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor. Have a good day.
Thank you.
In court today, Mr. Thurman stood before the judge as his case moved toward a preliminary examination. Another defendant asked for bond reduction after missing hearings, but the judge wasn't convinced. With prior probation issues and substance use admitted, the court denied bond changes. Instead, strict probation terms GPS monitoring, and upcoming review dates were set. The courtroom was filled with tension, accountability, and second chances, showing how justice balances mercy with responsibility.
I'm Lord Yagi, Assistant Public Defender, with on behalf of Mr. Wren, who's approaching. Mr. Wren, could you say your name for the court?
Douglas Wren.
Your Honor, I have been in communication with the people on this matter. There's no offer available, and so I do believe discovery is complete. We would ask that this be set for them.
People have their witnesses available September 2nd. Preliminary examination in person September 2nd, 2025, 9 a.m. That is before Judge Freshour. Bond will continue.
Thank you, Your Honor.
Court calls case of the people versus Mary Collins. Collins, I think it's.
Robert, on behalf of Mary Collins, who's approaching the podium. Ms. Collins, can you get up here, please, state your name for the record?
My name's Mary Collins.
Thank you.
And one just says the date and time set for probable cause conference. We are working on mitigation, so we ask for a brief adjournment at this time.
Without objection, probable cause conference will be adjourned September 4th, 2025, 9 a.m. Bond continue.
Thank you, Judge. Hi, Mary. You're awesome.
Court calls case people versus Maria Brand.
Alexander, on behalf of the people, Your Honor.
I'm Lord Yagi, Assistant Public Defender, with on behalf of Ms. Brand. Ms. Brand, can you state your name for the court?
Zaria Brand.
Sure. All right, I have before me a plea sheet that indicates that the defendant would be pleading to count 3, domestic violence, a 93-day offense. Upon a successful plea, counts 1, 2, and 4 would be dismissed. Defendant is agreeing to.
This is where it gets interesting. Plea deals. 3 charges dismissed in exchange for pleading to 1. Sounds like a bargain, right? But remember, the defendant must admit guilt in open court. There's no hiding. Here it's a trade. Certainty of outcome versus the risk of trial.
Pay full restitution, and there's a sentence agreement or recommendation to sentence under 7694A. That's the court's full understanding of it.
And that's correct.
Yes, Your Honor.
All right. May I have her sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Zaria Brand.
All right. Ma'am, it is this court's understanding that you're going to plead guilty to the charge of domestic violence. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Do you understand that?
Yes.
All right. You understand also, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Yes.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
I plead guilty.
You understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5 on that form. You'll see a copy there. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Anybody promise you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense?
Yes.
Seriously? Of course, hold on one moment. Here we go. On the date of May 19th, 2025, at the location of 755 Campbell Avenue, apartment 12, Ypsilanti Township, Washtenaw County, State of Michigan, what do you do on that day involving a Marquise Maddox that makes you think that you're guilty?
I threw a nail gun.
You threw a what?
A nail gun.
You threw a nail gun?
Yes.
At him?
In the direction of him, yes.
Okay.
It never made contact.
Okay. Good. But you were intending to place him in some apprehension of that contact happened?
Yes,
Yes. All right. And who is this individual to you?
my son's father.
Ma'am, I would have to advise you that if I do accept your plea, if you commit misconduct between the time of my acceptance of the plea and the time of your sentencing, any sentence evaluation in this case, the court would no longer be bound by, and you would not be able to set aside your plea. You understand that?
Yes,
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor. No, Your Honor.
All right. And have I complied with the court rule? Would it be proper to accept this defendant's?
Yes, Your Honor. Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 3. Counts 1, 2, and 4 are dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
September 22nd at 10 a.m. Judge Washington.
September 22nd, 2025, 10 a.m. That is before Judge Washington. Bond with its conditions will come.
Your Honor, I apologize. May I address a bond condition?
She's out.
I understand. She does have a tracking
That to be
tether.
changed?
No, Your Honor.
Okay. Go ahead.
She does have a tracking tether. I believe she's had one since May. Is that right? Since she was arraigned on May 20th, which is the date after the incident in this case.
After she threw the nail gun?
Correct, Your Honor.
Okay, go ahead.
There's, to my knowledge, been no bond violations. Ms. Brand works. She's a working mother and she's in school. So she's starting her semester in just a few weeks at WCCC, studying psychology. And so she has a she's very goal-driven and focused and wants to become.
Is she at Wayne County or Washtenaw?
Washtenaw. Did I?
Yeah, you include one too many C's for Washtenaw. You've done that like 3 times already. It's okay.
Thank you for correcting me. I apologize. Okay.
You're welcome.
WCC.
Yes.
Okay. And she, so she would ask, given her lack of bond violations and her close supervision, now that she's pled guilty, she understands that any misstep, any violation will not only compromise her liberty in terms of going to jail, but it will also compromise her record and her future career in terms of losing 4A. So I would ask if the court would consider removing the tether.
Response.
Your Honor, at this point, I would object. I think it's something that could be addressed at sentencing, but given the facts of this case, I would ask that the tether remain at least until sentencing.
Sorry. What I'm going to do is I'm going to let Judge Washington's probation department make a determination after they at least interviewed her before that tether is removed. So at this point, I'm going to deny your request for a bond.
Understood, Your Honor. Thank you.
Thank you. Court does call the case People versus Dominic Brewer.
Ahmed Adush with and on behalf of Mr. Brewer. Please state your name for the record.
Dominic Brewer. Thank you.
Your Honor, we're just asking for a short adjournment, please. About 3 weeks, if Your Honor is willing to do so.
Probable cause conference, September 4th, 2025, 9 a.m. Bond.
Thank you, Your Honor.
Thank you, Your Honor. Thank you, sir. Court calls case People versus Andre Brooks.
And on behalf of people. Assistant Public Defender Chelsea Virgil, and on behalf of Andre Brooks, please state your name.
Andre Brooks.
We'd like to start a preliminary exam.
Discovery is complete.
I believe so, Your Honor.
You will have their witnesses available to second. Preliminary examination in person, September 2nd, 2025, 9 a.m. That is before Judge Perry. Bond will continue.
Thank you, Your Honor.
Thank you. Court does call the cases of the People versus Eric Buckner.
Ready then.
Joseph and Nolan.
I'm Brown, Deputy Chief Public Defender, and with and on behalf of
Buckner will approach the podium. Mr. Buckner, state your name for the record. Eric Buckner. Buckner, at this time, we're respectfully requesting an adjournment of a little over 2 weeks. Mr. Buckner has medical appointments. He also would like to be able to decide.
Sorry. He has medical appointments?
Yes. Have.
Will the 4th work?
Yes, 4th, please. You need to see the.
Probable cause. Wait a second.
Just proof of his medical. He's got 3. That's okay. All right, thank you. No word.
Probable cause conference September 4th, 2025, 9 a.m. Bond will continue.
Your Honor, may we address just one aspect of the bond? He is out, but he's on home confinement. He has a lot of these medical appointments, and they're going to vary, they're going to change. Just asking that the bond be changed to maybe a GPS so that he can go to work as well. He does need to be able to work to be able to pay his rent. He's got bills that are coming up. The home confinement prevents him from doing that. But mostly it's the medical appointments. He has 3 verified appointments that are coming up very soon. He's going to have more after that. So we're not asking that he just not have any kind of supervision, just a different kind.
I would indicate, I guess, I don't need a response necessarily from the people doing that request, but what I would do is I'm going to leave the home confinement in place, making an exception for a verified medical appointment. So we just need to turn that into community corrections.
Okay, can he also do employment too? Because the home confinement prevents him from even working. He's got to be.
No response regarding the employment. Is that, I mean, for employment to work, to actually work, or
yes,
interviews?
No, I actually have a job, Your Honor. He does have a job. I have a job.
Your Honor, but the definitive of verification of that employment.
Okay, sorry, got something here.
All right, so what I would do, Mr. Brown, if you prepare an order, get it over to the prosecutor's office, so it had to be today. Otherwise, signature allowing his attendance at the medical appointments as well as employment.
Okay.
I will sign off on that, or that can get over to community corrections.
Yes, thank you very much, Your Honor.
Thank you. And September 4th, bond will continue with those changes. Courthouse case, People versus Maurice Burgess.
And the children that bring on behalf of the people.
What's called?
Burgess.
Burgess. Left row. Somewhere scrutiny.
I apologize, Your Honor. Lauren Daffy, Assistant Public Defender, with and on behalf of Mr. Burgess. Could you state your name for the court?
I'm Maurice Burgess, Your Honor.
Your Honor, may we approach on this matter?
Is there really a need?
There's a lot of updates that I've been talking with Mr. Burgess about, and
is that to the use of recreational marijuana, which he's not supposed to do, or to the cocaine? Which is the update?
Well, it concerns both, Your Honor. It concerns all of the steps that he's taking, and specifically the documentation that he went to Home Division yesterday, and we are waiting documentation, and
Documentation for what?
that he did his intake at Home Division yesterday.
As well as CMH.
As well as CMH. And he came in with a written plan in his notebook, and I can honestly say I did not even tell him to do this, but he came in with a written plan about how he's going to stay clean.
If I test him today, is he going to test clean?
Yes, sir. But I won't in 2 days. Your Honor,
What?
Your Honor, I'm not lying to you. Judge Simpson, I've done everything that I could possibly do to make sure that I can continue to stay in society. I have a job. I start tomorrow at Full House Restaurant on Equals. I went to CMH and did my intake. I also...
Inside the courtroom, lawyers pushed for adjournments, bond reviews, and plea deals. One man admitted his mistakes, saying he just wanted a chance to prove himself, while another faced tough questions after failing probation requirements. The judge made it clear, compliance and honesty are the only way forward. Bond reductions were denied, probation orders stayed in place, and new hearing dates set. Real stories, real consequences. This is what justice looks like when the gavel comes down.
I can give you my.
What are we doing with this case?
So I do have a green sheet, Your Honor. This is a case that is from, I believe, 2022. It's a possession. And I would ask to adjourn it because I'm hoping it comes to some sort of resolution. The bottom line is Mr. Burgess knows that he needs treatment. And I've had a lot of conversations with his fiance and him, and I really do think they are very active in making sure that he gets help, stays out of trouble. He just got this job. He has the sweatshirt that he's wearing. And he's eager to prove himself. And I think he's very genuine when he says, I mean, he asked me to ask this court to let him prove himself and to show with his actions that he is following up, that he's good to his word. I did call Home Innovations this morning and verified Mr. Marcus. I'm just waiting for his email response to come through, that he did actually go to the meeting yesterday. I did verify with his fiance, who is with him, that he did that, and that he is clearly not using. He came to court knowing that he had this bond violation, knowing what he risked in terms of his liberty, but he wanted to do the right thing, and he wanted to stand before this court to ask for the opportunity to show that he can be clean, he can be sober, he can be in the community, and he will do the right thing. He's very eager to prove himself. He has no other cases, not on probation or parole,
and here we see the raw human side of justice addiction, second chances, and desperation. The defense paints a picture of a man trying to climb out of his own mistakes, but the judge has to ask, is this genuine reform or just courtroom promises? What would you decide if you were on the bench?
He has this new plan.
Recovery coach, new plan.
And he's going to Little House meetings multiple times per week.
I start work tomorrow, y'all. I just need an opportunity to prove to you that I can do the right thing. I know I made some mistakes, some horrible decisions. I'm 62 years old. I'm old enough to know right from wrong. And I apologize for my shortcomings, but I'm trying to do the right thing. I can't prove it to you from there.
I have 4 positive tests. He's been using cocaine. Almost less than a week ago, I have a positive test regarding that.
I understand.
He doesn't have a valid medical marijuana card. He's also been using marijuana or THC at least in the system. You're telling me now, the day before he's to come to court, he's now in treatment.
I started
and somehow or another, I'm just supposed to say all of that's okay.
Well, Your Honor, he knows it's not okay. I think what makes him really different is he is coming, he is testing, and he is doing his best. It is obviously a struggle for him to battle his addiction, but he is not getting in trouble. He's going to meetings. He's doing the best that he can, and I think he's doing what, especially on his own initiative. I mean, I was surprised yesterday because he doesn't have his own cell phone. He shares with his fiance, and before I even talked with him, he came up with this plan himself, and I think that goes to show that he's taking the initiative to do this himself, and he is using this added accountability of testing. He knows that he's going to lose his liberty if he tests dirty one more time. I mean, he knows that. And he knew that coming into court today. And he still came in anyways because he wanted to prove to the court that he is willing to take that chance. And he said, the court certainly will revoke my bond if I test positive again, but I'm not going to because I'm serious and I'm serious about recovery. And so I would ask this court for one more week, one more opportunity for Mr. Bergens to prove himself.
I can do it, Your Honor. I promise. I'll be locked up if I don't. I can't do anything from jail. I have a job now, and I want to prove to myself as well as this court.
Anyone can do jail.
Sir?
Nothing.
I'm sorry.
I'll adjourn this out to the 28th, 2025 at 9 a.m. I don't need a response from the people. Defendant's bond is revoked. If you send me the proof that he's enrolled, I'll reconsider the revocation of his bond. But until such time, his bond's revoked, defendant will handle. Mariam, something. Yeah.